And welcome to the Halloum Business Competition final round for 2022. My name is Natalie Winters. I am the director of the Advocacy Competitions program here at the law school, and we are so excited to have you with us as we watch what will actually be a live negotiation happening right behind me in just a couple of minutes. So I don't want to take up too much of our time. It's going to go by fast. But I did just want to give you a bit of brief background before we get started so that you know what you're going to see today and also have a chance to recognize our amazing finalists who've made it here today after beating out a number of other teams in a preliminary round, which actually occurred virtually, and then an in-person semifinal round, which was last week. This experiential education opportunity that is the Halloum Business Competition is actually a partnership between Berkeley Law and Haas. So we try to get business and law students together so that we can learn from each other in a school environment before we ultimately head into the real world and tackle those challenging transactional negotiations like the one you're going to see here today. So today's session is being recorded, so please keep in mind that any side conversations in the back should be very quiet, if not non-existent. We really want to show respect both for our finalists and our volunteer practitioner judges who are with us here today. I'll introduce our judges in just a minute, but first I want to tell you about the case problem you're going to see. So this is a hypothetical case problem that is based in part on some real-world scenarios that we're seeing unfold in real time right now. This year's case is about a wealthy car company owner who has successfully negotiated a purchase price for privatizing Twitter, a social media company. But suddenly, war breaks out abroad, and Elon Musk, the car company owner, wants to get out of this deal. So she communicates her intention to Twitter's CEO, Jack Dorsey. There are some key terms you may hear finalists discussing as they negotiate today, things like claims of breach, or purchase price, or settlement agreement, or termination rights. But before we get to that, I am proud to announce to you this year's Halloum Business Competition finalists, and they're standing right in front of you behind me. They are Robert Ivan Flores Rangel and Elizabeth Garcia. If you want to give us a wave, round of applause for them, please. Thank you. And they will be representing Jack Dorsey of Twitter. On the other side of the table, we have Snovia Moiz and Elizabeth O'Grady representing Elon Musk. Round of applause for them, please. So over the course of the next hour or so, you will have a chance to see these two teams negotiate. They're going to actually jump right in after I finish talking, and we'll have about a 40-minute negotiation where they try to determine how the two sides are going to go forward from here. After that, they'll take a brief break, and then each team is actually going to come before our panel of judges and talk about how the negotiation went. What was their strategy? Was it successful or not? How did they think that the negotiation ended up for their side? So you'll have a chance to hear that kind of inside baseball from our finalists directly. Once that's done, our esteemed panel of judges here will deliberate. We'll actually hand out an audience poll so you can tell us who you think won the negotiation. Of course, that final determination will be made by our judging panel, and we are joined here today first by our competition's founder and partner at Freshfields, Joseph Halloum. If you want to give us a wave, Joseph. Round of applause for him, please. Next to him is M. Landon, one of our negotiations professors here at Berkeley Law. Wonderful to have M with us. And next to her on the end here is Clint Wasted. He is the head coach of our ADR team at Berkeley Law and also the founder of EMI Foundation, which does similar sort of negotiation transactional work. So round of applause for Clint for being with us today. And without further ado, finalists, when you're ready, the floor is yours to begin.
Thank you.
Well, hi. Thank you for meeting with us today. Would you like to get us started?
Yes, thank you, Elizabeth. It's a pleasure for you being here. We're dealing with an important negotiation for our client, which is also really important for your client, so we're really glad to have you here. As previously you noticed on our fact sheet, we're discussing 4 important points in which we definitely would like to have a deal. It's the claims of the breach for the fake bot Rangel team, the purchase price in this negotiation, the termination right, and the settlement agreement. We are really grateful for hearing first of you what are your expectations in the negotiation and what you're looking for in this deal.
I think overall we want to come to a settlement that's in the best interests of both parties, and we want to ensure that we keep this matter from going to litigation because that's costly and time consuming, and we want to get this done here and negotiate in good faith.
Yeah, we're definitely on the same page on getting to a settlement agreement and avoiding litigation, so
Perfect.
Thanks. All right, so.
Well, at least we have a first agreement. We definitely will look also for a settlement agreement and avoid the litigation. Therefore, in order to avoid the litigation, the first thing regarding the claim of the breach of the fake bot, we would like definitely your client to dismiss and to let out any claim that is related to the claim of the breach for the fake bots information. I don't know if it's under your ear, if you also have this as part of your negotiation, or do you mind not be part of this deal directly?
Yes, we have some information on that from our client, and our client would really like to keep that in because she believes there are far more fake bots on Twitter's platform than are currently allowed, and she believes this claim is completely valid and that she would win the suit if we were to go. So she would like to keep that claim.
I just have a question regarding that point. In previous negotiations, Ellen was really set on wanting to have an external team to investigate the fake bot accounts. And out of those negotiations, we came to the agreement that there would be a team that would investigate the fake bot accounts that Ellen was concerned with. So she did get that agreement. I'm just wondering where the concern is coming from and why it's still a continued concern.
I think the biggest concern Ellen had is that during that investigation, she wasn't allowed to access all of the confidential information necessary to determine the fake bot situation. So I think that's our biggest concern there.
Okay, and by confidential information, can you please elaborate what Ellen was hoping to get access to?
Yeah, to be very honest, we wouldn't know either because we don't have access to that confidential information, but I think more information from Twitter's teams regarding how they analyze fake bots, how many there actually are, and so forth.
Yeah, and I just want to say that this is a very valid concern. You know, obviously you want to make sure that what you're purchasing is priced accurately. But we did conduct an internal investigation, and it was led by our client, and our client does trust the team, and there weren't any documents showing that Ellen's concern was founded. So that's the reason why there aren't any documents. It's because nothing produced evidence otherwise.
Yes, but because she hasn't had her complete full access, and her initial findings did yield that there could be more fake bots than your internal review found, so it's a claim that she would like to keep.
Okay, I understand. Is there any way that we could potentially come to an agreement to maybe have Ellen involved in the investigation of the fake bots and maybe avoid having to go to litigation, because ultimately that's both of our goals. So if there's something that we could come to an agreement with regarding maybe addressing that specific concern and getting her to drop those claims, is that something that you would be open to?
I think we'd love to maybe table this conversation, discuss one of the other kind of 3 items that you mentioned at the beginning, Roberto, and potentially come back to this item.
Really? Yeah, that's fine. Okay. So in other terms, we're looking for about the purchase price. Now, I think it's really concerned on what is going on in the USA stock market in recent times and also what is going on. So In this case, definitely we're open to hear what you have in mind regarding the purchase price. Our client principally wants to maintain the price in the terms in which we make it under the deal, the initial negotiations of the acquisition. So I don't know if you have something in mind or you have any other idea directly to that.
Yeah, I think so. What Ellen's primary concerns were that the agreement was made before the stock market was in its current condition. So she does have a concern that she would be grossly overpaying for what the company is valued at now. And I think Elizabeth had more of an idea in terms of what we're looking at numbers-wise.
Yes, we're looking to come in at $40.07 per share. And the reason we got to that number is we looked at a very similar social media company that looked at their historical stock averages, and this company was also trading at about $45 per share back in April, and now is down. So based on that, we're looking at this 40.07. Just a little, I'll leave it at that.
Okay, so your offer price is $40.07 per stock. Okay. And when we did enter into the merger agreement, the stock price was $54.20 per share.
That was what we agreed to pay, but the price was actually $45.
So, right. But you're purchasing a company that is the only social media company in the world that can offer Ellen what she most desires, which is a platform for free speech. So she was paying a premium to acquire that company.
Mm-hmm.
So I guess given the economy, we're no longer willing to pay such a premium. So just digital advertising makes up 90% of Twitter's revenue, and it's been falling as of October 2022. Also looking at some comparable companies in the industry, looking at Meta's profit within the past year, looking at Alphabet's profit in the last year. Both of them saw incredible profit drops. Meta's profit most recent quarter is down 50% from a year ago. Alphabet's is down 27% from a year ago. So just looking at how the economy is changing, I think the deal that our client had agreed to in April no longer makes sense given the financial situation.
And I know that the market, we're currently in bear territory, so most stocks are going down, but Twitter has actually held up pretty well. And I just want to remind you, stocks will fluctuate given market conditions, but Twitter is the only company in the world that can give your client what she seeks. And I understand that we're in bear territory, but Twitter has held up pretty well. And I would even argue that there isn't a comparable platform because there is no other social media company that allows you to have dialogue and engage in conversation on a worldwide platform the way that Twitter does.
We totally agree, and we see your point there, but the issue is, while these issues are still very important to Ellen, grossly overpaying in this economy doesn't make sense the way things made sense before the market worsened, especially now that we're looking at all the financials in this sense. And the idea at the time was that things would improve in the market, and now we see things are getting worse. So while we do still want to come to an agreement, we can't really justify the gross overpayment.
Right. And I think that there's room for discussion on that point. I think we should reframe the term grossly overpaying because ultimately that was the price that we came to in the merger agreement. And previous case law actually supports that courts tend to side with the purchase agreement price in the merger agreement. So I understand that unfortunately market conditions have changed, but that was the price that we agreed to in the contract.
Yeah, definitely. I will also add what this Elizabeth saying about the president and supporting the regional pricing transaction in courts, also related with the cost of litigation, which could be added definitely to the financial sheets you have right now in your papers. I mean, if we continue with the litigation in that and it continues supporting, also the litigation sheet will appear on the passive of the company definitely, and it would not be a good idea for continuing growing the company in the future. So definitely, I think 45.20, which is the regional price, it's our initial propose, and yours is $40.70, really? $40.07. Okay.
What,
I think.
Sorry, can you repeat your initial offer again?
Yeah, it would be the regional price that is $45.20.
$45.20 per share.
Yeah.
Yeah, which is that renewal. And I mean, as we continue discussing, probably we have more space to continue this discussion and reach probably an agreement. But I think our offer is that in that
So,
sense. We haven't any.
Yes, we are willing to negotiate down only if Ellen drops the claim for the fake bots, and we can avoid litigation.
We also want to avoid litigation. I think that's in our best interest. Would love to talk about, I think, so we've given our opening offer 40.07, you've given yours 45.20. Would love to talk about the timing of this, the settlement agreement, something that is important to Ellen. Just it takes a long time for her to get her financing stack. As you know, $44 billion is a lot of money, so it takes a little while to make those, to get that debt and for her to be able to sell her shares. So yeah, we'd love for a settlement agreement if we could have 5 months for our client in order to then be able to make that purchase.
Okay, probably we have to discuss that. We will continue discussions regarding about the time for the settlement agreement. But regarding the time, it's really important for our client in order to avoid continued possible litigation and also the stock market dropping. It's really important for us to continue under terms and the business has just been developing. So definitely we're looking for a 3 months settlement agreement in which the deal concludes. I don't know if you want to add something more to this. But.
Yeah. And that would be at the $45.20 purchase price, with the addition that she drop her fake bot claim. And another thing that's really important for our client is to make sure that Ellen also drop her termination right, because as it stands right now, she can walk away from the deal if her financing commitments fall through. So we would agree to a settlement agreement as long as she drops her termination right and her fake bot claims. And we would leave it at $45.20 with a 3-month closing time.
I think what would be hard for us would be to convince her to drop both, because in that way she's giving up 2 of the things she really wants and not really getting much in return. So is there one that's more important to you?
I think ultimately what's more important to our client is completely avoiding litigation and coming to an agreement as quickly as possible. And I think that that's also in the benefit of your client, because ultimately your client is purchasing Twitter. So it's in her best interest that the company retain value. I would definitely say that there's room for negotiation on the deal time, the closing, and what is more important would definitely be dropping the claims of the fake bot merger term.
So if we were to drop the fake bot claims, would you be open to Ellen keeping her termination right?
And also potentially increasing the price per share, lowering the price per share.
I will say putting up a price in the purchase price would definitely be in the table as we continue negotiation. So definitely we can consider that as part of this negotiation, only if Ellen decides to drop both of the claims we're talking about.
As I previously stated, I don't think it would be possible to drop both, but we would be able to maybe get some leeway on one.
Well, why don't we focus in on our client's goals? Can you please elaborate on what Ellen's ultimate goal is?
I think we agree with you in that we want to avoid litigation. We want to settle this here and now, and it doesn't benefit anyone to drag this out. So I think we're both clear on that we do not want to litigate. Ellen does want to purchase this company, but she wants the agreement to be revised considering the current state of the market.
Okay. So she wants the agreement to be revised. So if I'm understanding correctly, one of her main concerns is feeling that she's overpaying for a company that is not priced at what it was when she entered the merger agreement. And that's definitely something we can work on, is lowering the purchase price per stock. In terms of termination rate, I think one of the main reasons why that's also something that we would like for her to not have the option to use to get out of the deal is that ultimately we want both of our clients to walk away happy. And our main concern is just that she would follow up again and try to get out of the deal if she doesn't drop the termination rates today.
Yes, we understand that. I think one thing that you mentioned previously is that kind of as the contract currently stands, how those hold up in court. And because she currently has a termination rate in her current contract, that is one reason she'd like to keep it. And just as you know, this is a very expensive purchase, and given that the economy is continuing to go down, she is worried that it could be challenging for her to make this purchase, which is why she would like to keep it. To be clear, she doesn't want to use that termination right. She doesn't want to have to pull that trigger. She wants to purchase the company. That's her goal, because the fine of $1 billion is still a lot of money, even for someone like our client. But she just likes to leave the option open for herself.
I understand. So maybe there's a different approach that we can take, because if she still wants to have the termination rights, and our client's concern is that at some point in the future she will attempt to get out of the deal again, is it more of a concern that she will not have the financing, or is it more of a concern that she's going to have to use all of or a significant majority of her Tesla stock to finance the purchase? Maybe there's room on that we can work on and negotiate within the termination right, to where maybe we can add a condition to the termination right, or we can eliminate it if we give her some other kind of benefit.
I think we're open to having those discussions.
Okay.
But the termination right is very important to her.
Okay.
To give you a sense of scale.
But to be clear, she does intend to purchase this company, but obviously her car company shares have been hit by the current market, so that is making things a bit difficult. But I think where we stood when we made the initial agreement is she wants to purchase the company, and that's still where we stand now.
Okay.
I think so. We have the most important concern is that she wanted to buy the company, but she don't want that affect a lot with the economic crisis on the stock market. Mm-hmm. So we agree with that, and I think we should probably have another offer regarding the purchase price for you. That it would be, we have the purchase price in $43, which would lower the value, and we are in exchange of that. We are looking for drop both of the terms we have discussed in the last minute.
The termination
The
right.
termination right, and also definitely the fake bot allegations.
And what timeline for settlement agreement would you be looking at?
We can, given that package, we could definitely work with your client and have it happen within 5 months.
Yep.
Okay.
I don't think that will work for our client. I think just a reminder here for both of us that Delaware courts won't be able to hear any sort of case until 2023. So I think we're making progress, and I think we can do this, because it'll be much faster to do it here than to go to courts. That will be bad for all of us, including, I know your client wants to move on to new endeavors. I know he wants to get out of Twitter, get a new job, maybe go on vacation. I don't know his plans, but yeah, so just want to keep that in mind here. But I think we are making some progress. Are you able to come down, if, would your client be willing to do $40.50 for the price?
And if the price is accepted, we'll have both of the terms out of the deal. I mean, it's the fake bots and also the termination right out. Okay.
I think we'd still like to keep the termination right.
Definitely the fake bot we can work on. The termination right, it gets a little messy, but it is something we can consider.
Okay.
I guess I'm just having a hard time understanding why Ellen would like to retain the termination right if she wants to purchase the company. Like, there's something that is not making sense to me. It just seems like we're willing to lower the stock price, we're willing to shorten the closing deal time, but she still wants to retain the termination right. So that is concerning for us because it indicates that she still wants to have some kind of out, and we just really want to address the cause of why she wants to retain it.
Yeah, I think the biggest thing for us is that she is concerned that market conditions might worsen in the future and that would affect financing.
Okay. I mean, market conditions might better. So it's not a given that they will continue on a downward trend, and this deal might actually be better than her continuing to prolong the process. And stock prices could take a turn for the better tomorrow, and then she would have to pay more money.
So can we ask what Jack's goals are from this negotiation?
Yeah, I think Jack's goals are definitely to come to an agreement today and close the deal as quickly as possible and just allow him to move on to future endeavors, you know? He wants to give Ellen what she wants, and he wants to make sure that they can both walk away happy and avoid litigation, because that will be costly for both sides. It will also be detrimental to the company that Ellen wants to acquire and that Jack built. So ultimately it would be ideal for us to come to an agreement today, and that's why it's really important that we understand why Ellen is so apprehensive to give up the termination right.
I think it's like we previously stated, it comes down to financing. So what is the current stock price we're discussing right now?
Well, right now we have two differing offers on the table, and maybe would it be helpful if I wrote them on the board? Okay. So I'll write down our best offer. So this will be like our column. Did I summarize?
Yes.
Yes.
No, I
No,
think I got this one
it's
backwards,
both.
actually.
Yeah, exactly.
Sorry. I wrote it on my paper opposite.
Don't worry. Correct. Okay, I think we have made a good summary of what we have been discussing, and it's really important to have it in the picture. Thanks so much, Elizabeth, for putting on that. I mean, I think just to cap on again, and what we have been discussing in the last minutes, it's the principal concern of your client. It's related to the financing time. Okay.
Right.
So if you don't mind, Elizabeth, I think we should have our 5 minutes break, just to put in mind, because I think we should probably give you a better offer regarding the price of the share, and with that, I probably think your client would definitely be more safe regarding that the financing time. Okay.
Okay.
That's great.
All right, so our teams have elected to take a 5-minute break. That is a strategic decision that each team has available to them during the course of the round. It can be used for a number of reasons, and I'm sure we'll hear about why a break was taken during the analysis portion after we finish the negotiation. But I wanted to make sure you know we're not done yet. They're not at an impasse, but this is part of the competition. They have the option to take a break. When a break is called, both teams have to leave the room. So once those 5 minutes are up, they will come back in. Feel free to grab yourself another drink. Otherwise, we'll get started in just a couple of minutes.
Okay, girls. We're looking for numbers and really concerned about your client principal affection that is regarding the financing and the drop of the stock market in the next months. We are thinking on accepting your price per stock that it's put it in the whiteboard, 45, but only if the settlement time we can reduce it to 4 months, and we remain with the drop of the fake bot and the termination agreement. Just for letting more arguments to the price, we are considering that according to the stock market information, the stock market has been dropping between the 20 and the 30% of the stock price in the recent months. This price would cover definitely a drop. It's more than the 20-30% discountage from the 54.20 that it was the original price established in the acquisition. So considering that, we think 40-50 would be a good deal, but having 4 months in the settlement time and dropping the fade bot and dropping the termination right in the acquisition.
I think the biggest concern, we really appreciate you meeting us there. I think the biggest concern there becomes for us the termination right, because the more time we can get, the more we can ensure that we will have the proper financing. So I think 4 months is where we come at an impasse.
But I think we would be willing to, if we are willing to drop this termination right, if we can increase the settlement time. And the reason for that really is just the amount of time to get the financing. You know, if we can't get the financing in 5 months, that extra month could really help us, especially thinking about how the economy is going up and down. Like, that extra month to weather it could help us.
And I think by dropping the termination right, we show that we do intend on purchasing the company. We just want to make sure everything is in place.
And would you also drop the fake bot, or would you?
Yeah, we can drop the fake bot.
Yes, given this package, we could drop that.
I think that works with our client.
Okay.
So we have a price at 40-50, up per month for the settlement.
6 months.
6 months, sorry, and drop the fake bot and drop the termination right.
Yes.
Okay.
Are we at an agreement?
We have an agreement.
Okay,
We have a deal,
perfect.
definitely. Thank you.
Well, we don't guarantee that an agreement will be reached. So we are very excited to see that our parties were able to not only get on the same page about one term, but actually reach an agreement on all 4. We're now going to take a pause so that they can have their 5-minute break to prepare for the analysis that they will give to our judges panel about why they did the things they did. So stay tuned. We've got more action coming for you shortly. All right, ladies and gentlemen, please go ahead and find your seats. We're going to get started with the analysis from the LL.M mask team. So they've got 5 minutes to talk with our judges. Judges may have some questions for them. We will see. But I'm going to hand the mic over to them, and we'll hear from LL.M Mask's team how they think the negotiation went today.
Hi, everyone. Thank you for coming. So overall, we think we got a pretty good deal for our client, based on the fact that before the negotiation, we ranked our clients' priorities, and in the order we had them was the settlement time, the purchase price, the termination rights, and the fake bot. And we were able to basically meet our clients' priorities in all of those. The biggest thing that was difficult for us was the termination right, because our client really did not want to waive it, but we were able to do that under certain terms in the agreement, which was that we could waive it if we came to a certain settlement time or purchase price, and we were able to get that for our client. Based on the priorities we had set, we tried to leverage what we could. So fake bot wasn't that important to our client, but we realized it was very important to them. But we tried to keep that to ourselves, and so we could use that to negotiate on something that was more important to us, like the purchase price. And I think what was really important to us was being upfront with them, but also keeping a strong position in the sense of not putting everything out there at once. So we believe we met our client's top 2 priorities, and we had to negotiate a little bit on termination right, but we did it within the conditions that our client was okay with, and we realized that was a hard line for them, and if we kept pushing on that, we might have lost other factors of the agreement.
Yeah, so a couple things we think we did really well. Beforehand, we had our bottom lines very clear, just like with the table, because there were the purchase price, the settlement agreement, and the termination rights. There wasn't one bottom line for all of them. It varied. So we had a little table with that. So I think coming in with that very clear was helpful. As Snovia said, we were really upfront and we kept our strong position. And I think part of that was we tried, when possible, to give the first number to set the anchor, so that we were starting from a position of strength there. A couple of things we could have done better. We think that we did end the negotiation about, I believe, 8 minutes early. So potentially we could have kept pushing on termination right. As Snovia said, though, the reason we didn't is because our client's top priority was not going to court over this. So we didn't want to risk ill will by pushing that to the last minute. And then I think the other thing we could have potentially done a little bit better is, we didn't really care about the fake bot claims so much. And I think we did a good job being strong with that in the beginning, but then near the end we just kind of let it drop off and erased it from the board. And I think we maybe could have held it out that a little longer to get a little bit more leverage. That's anything to add, Snovia? No?
Sorry, let me make sure we have a mic on that question from Joseph Halloum.
What was the most important term for you?
We believe to our client the most important term was settlement time, on the basis that our client was most worried about getting financing and the right amount of time, and given settlement time would allow her to get the correct financing, and she didn't seem to care as much about the other factors.
Yeah. Close second was purchase price, or way up there, and they kind of went hand in hand.
So we're going to now hear from Jack Dosser and Tweeter's legal team.
Hi, thank you so much for taking the time out of your day to judge us today. I think Roberto and I, some of our strengths were really to try to get down to Ellen's goals, to really find the source of where her requests were coming from, why she was asking what she was asking for, and really make sure that we're understanding the underlying motivations. I definitely think that one of our weaknesses was that we could have been a lot more clear on why it was important for us to make sure that she dropped the termination right today, and really making sure that we made it clear that one of our biggest concerns was that Ellen try to do this at a later time in the future, which was our client's biggest concern. We didn't want to have a negotiation like this at a later time if it was something that we could come to an agreement on today. And just being friendly and collaborative with the other team. When we enter negotiations, we really think about them about expanding the pie. How can both sides get what they want and still walk away with an agreement that benefits both of them? And one that is fair, right? Because you don't want to be negotiating with someone that is completely overpowering the conversation and not being logical. So that's also something that really motivates our requests and making sure that we align with our clients' goals.
Yes, and specifically regarding the terms of the negotiation, I think we were under the terms that our client gave us. For the first point, it was really important for our client to really drop the cost of the breaches regarding the fake bots, something that was accepted by the other part. Regarding the price of the purchase, I think there was a deal because it was really important for the other part to really have a good price, lower from what we are expecting. And we have a range between the 35 and 44 USD per stock, which where we manage in, and $40.50. It's a good deal for those range. I mean, it's just in the medium part, which was something that benefits both parts. And also, our client was really aware about a termination right, which is something we do negotiate it correct, in which we obtained a drop from the termination right, for the termination agreement right, LL.M Haas. And also regarding the time for the settlement agreement was something in which we want probably have more time, less time to obtain a settlement agreement, but our client was in the disposal to put it in the 6 month time unless he obtained both the drop of the fake bot and the termination agreement, which was obtained by us, and we think we reach a good negotiation for the term of our client and also for the term of our partner's client.
Just part of the reason why we decided to go down to the 40-50 was really because we understood that Ellen's main concern was the financing, and we wanted to account for the drop in the stock market. So going down to that price would account for the range at which the stocks had decreased, but it still stayed within our client's range and didn't hit the bottom. Although it wasn't ideal, I think that a 40-50 share per price is much better than going to litigation, and we don't know how long that will take and if the effects that will have on the stock price of the company. So it wasn't the top that our client wanted, but it definitely came with all of the added requirements that he was seeking, and that was definitely part of the reason why we were willing to negotiate on the stock price. We just ultimately, our main concern was that we came to an agreement today and that we were working with the other side and really hearing them out and understanding where they were coming from and avoiding litigation, because that's just timely and costly and who knows how long that will take.
About a minute left. Yeah, any questions from our judges? Go ahead, Joseph.
So I know when you were talking about the purchase price, there was a comparable company analysis that you kind of spoke towards. What was the other company that you were referencing that seemed to mirror, the decline in the way you were adjusting for the purchase price?
And I'll ask for a brief answer on that because you've got about 30 seconds left. Yeah, thanks.
I think the Ellen's attorneys really did a good job doing market research and coming up with comparable companies. I think for us, our main point was really to hone in on the fact that Twitter's the only company that can provide her with the platform that she was seeking. Therefore, there wasn't quite an equivalent that they could compare Twitter to. So that was really what we were trying to get at.
All right, another round of applause for our finalists. Thank you, thank you. If you have not yet completed your audience poll, now is the time. Maybe you saw the analysis and you've completely changed your view on how things went. It's okay. You can still revise your vote. We will be collecting those soon. For now, our judges are going to go ahead and deliberate. We will have results in the next 5 to 10 minutes, so stay tuned to see who this year's champions will be. We do have the results of our audience poll. Before I share that with you, I'm just curious. Go ahead and raise your hand if you are a law student or someone that works at the law school that's joining us today. Okay, a lot of hands. Keep your hand up if you actually competed in the Halloum Business Competition. All right, round of applause for those folks for being brave and joining the competition this year, and thanks for coming out to see the final round. Hands in the air if you're from the business school and you're joining us today. Yes, a couple folks. Woo! Fantastic. And if I did not mention you yet, raise your hand and let us know where you're from. Who wants to share? Anyone I didn't mention yet who's joining us? Any LL.Ms in the room? Look at all those LL.Ms. Awesome. Fantastic. Thank you so much for being here, everyone. We are going to hear from our judges in just a minute who officially won the Halloum Business Competition, but we also care to hear from you how you think it went, who you think won. So the results are in. Before I give them to you, I also just want to take a moment and recognize our absolutely rock star student director this year, Lizzie Doktorov, who's sitting in the front row there. She single-handedly helped us put this on and also wrote the case problem that you saw herself in coordination with our competition founder, Joseph Halloum. So she had a huge part in what you had a chance to see today. We could not have done it without her, so thank you, Lizzie. Without further ado, the audience poll is in, and according to you, by a margin of 11-6, the winner was Tweeter. So that's what the audience had to say. We'll see what our judges say. I am going to run out and check on them in the Steinhardt courtyard, but we should have results for you in just a couple minutes, so stay tuned. Thanks. All right. We've got our judges back. We are going to hear a little bit of feedback from them before the winner is ultimately announced. But before we get started, one more final round of applause for our wonderful finalists here today. And let's see. With that, I'll go ahead and hand the microphone off to Clint. Get us started.
Okay. Well, good job by everybody, and impressive to get a deal done so fast. One of the things I want to say, and this is going to be broad feedback that will apply to everybody, is to just, when you go to do this in your career, think about negotiation. I heard people say in their analysis partially about how you would look at your particular numbers, how you do your approach about trying to be conciliatory, avoid litigation. But you also we need to do something proactive that helps convince the other side why they should take an offer that's on the table from us. And that requires us setting up some degree of narrative towards the general approach. And then that also is understanding what motivates the other side, so that when we put a number out there, we can follow that number with an argument that isn't necessarily here's what would happen in court or here's what the stock market is, right? But here's what's important to you and how this will help sort of facilitate something that you're doing. So I think, given that we finished with 10 minutes left and given that the numbers didn't move very much, we probably would have benefited from a little bit of effort towards taking an attempt at reaching for more and more naturally managing the conversation back to get to these numbers. I know there's not a lot of time, so it's hard. It's impossible, right? But to spend a little bit more time on kind of triangulating those three things when you make a case, because if what you don't want to do as a negotiator is show up and just report logistical results or things that we'll do, right? Anybody can do that. So how you can be a value add to the situation is to read what's important to the other side and to make sure you're emphasizing those things as part of what you're doing while you negotiate. And I think, so I would try to, as you go forward in your career, focus on that aspect of things. And it's more important in each instance in getting a deal or getting a particular number, right, is understanding how those three things connect, because these things will take months and months and months in real life. But good job by all, very eloquent by all. It was fun to watch.
All right, yes, great job. I completely agree. I think part of the job on the attorney's perspective with these negotiations is trying to frame the story. It's much more than just avoid litigation, we want to avoid litigation. Why, right? And I think we were starting to kind of get those questions, but a little late in the game about what's the reason behind this? And we start throwing numbers very quickly. And so I always like to say, just slow down. Breathe, think about it. What number do I want on the table? And listen to what opposing is saying. If opposing's not giving you a number, do not counter against yourself. Make sure to wait and hear back what opposing is saying and make them kind of justify what number they're giving out, right? So I think definitely I agree with what Clint was saying. I think it's an easy justification and explanation when you can try to frame it more as a story. And remember, all of these, what you're given, these fact patterns, it's all leverage. And we have to choose when we're going to use our leverage and when we're going to hold back, right? How quickly are we going to show our cards? Or, when am I even going to show my cards? So we just have to make sure that with every deal, with every offer, with every minute that we're trying to give and take something, that we're not giving away extra leverage too fast, right? And that's what we have to think about, who our client is. At the end of the day, what really do they want, or do they just want a deal, right? Can I push it a little bit farther so I can report back to my client and say, look how great I did, here's what I got, right? But overall, really fantastic job. It was such a pleasure to watch, and just thank you for your time today.
Yeah, to echo both Clint and M's thoughts, I thought both teams did really well, worked very well together, very productive, working across the table. I think, you definitely saw instances where each side played to their strengths. I thought on the Ellen side, played hardball, weren't willing to give up both terms. And you were also able to negotiate the price down quite a bit. And on the Jack Dozier side, I thought you kind of counterplayed that very well in terms of, even though the market conditions have changed, you said, well, if you want to buy a company, you got to pay a premium. And I thought you did a good job pointing out that it's not just what the market puts out there. I think that the one piece maybe just to take away from this is that you got to be willing to walk away and show that you're willing to walk away if you're not happy with a deal. And so I think that's an element to, yes, we'd love to see a deal get done in this lunch hour, but it also shouldn't compromise the position and maybe the leverage that one of the sides has relative to the other. But both teams did really well, and it was a tough decision for the judges, and I'll turn it over to Natalie to announce the winner.
Thank you, Joseph. And one last round of applause for our judges who came here to volunteer their time over the lunch hour. We're so grateful to you all. So without further ado, the winners of this year's Halloum Business Competition are Snovia Moiz and Elizabeth O'Grady. Congratulations.